Well, today, the Wisconsin Supreme Court negated a state abortion ban law. That law dated to 1849. At the time, Wisconsin enacted legislation that said someone who intentionally killed a woman's unborn child could face a $10,000 fine and 6 years in prison. One exception was allowed: to save the life of the pregnant woman. Well, spotlight fell back on Wisconsin's law in 2022 after the U.S. Supreme Court overturned Roe v. Wade, ending the constitutional right to terminate a pregnancy. With abortion law decisions back in the hands of the states, Wisconsin Governor Tony Evers sued to invalidate his state's 1849 ban. However, some state prosecutors say that they wanted to enforce the law.
Today's ruling marks a major victory for reproductive freedom following the uncertainty and harm to women's health that have resulted from the overturning of Roe v. Wade.
Meantime, Republican State Representative Chance Green, who represents parts of our region, agrees that the law should be amended, but he feels how the Supreme Court decided this case was wrong. Green believes it violates the separation of powers, adding that it's the legislature's jobs to change laws, not the courts. Meantime, Democratic Representative Angela Stroud is also responding to the ruling tonight. She represents the Ashland area. In a statement, she said a law written in 1849 should not dictate women's health care decisions. She went on to say abortion care is health care, and the government should not be allowed to intervene between a woman and their doctor.